In this High Court case, the judge described as pseudo-legal nonsense advice given to a couple who were indebted to start mortgages, which was a major cause in the repossession of their home. The judge described these people as legal charlatans. That is the topic of this episode. Hey, it's Terry Gorry, and this is the Irish Law and Small Business podcast. Case there involving legal charlatans, what the High Court judge has described as legal charlatans, which ultimately has led to a repossession order being granted against a couple from Wexford to start mortgages in respect of a loan of 60 grand. The background to this case is that in 2011, I think it was, the couple, the defendants, defaulted on their loan, mortgage secured loan. They owed about 15 grand at this stage, 15,000. Had they engaged properly with START and sought a solicitor or consulted with MABS, that's the Money Advice Bureau Service, the judge had no doubt that a deal could have been done and an arrangement could have been made. They did not do this. They took the most unwise stance, according to the judge, of engaging in ill-advised correspondence with START, and they stopped making payments in 2017. So the 15,000, which started off in 2011 with the default, is now 60,000. But according to the judge, they appear to have fallen into the clutches of unregulated charlatans who sell vulnerable people, indebted people, a crock of nonsense that there's some legal trick to avoid repayment of lawfully incurred debts or to have downloaded documents from such fraudsters. This is the sort of pseudo-legal nonsense that I made a video about before, which was about people giving advice to debtors who owed the banks quite a bit of money from, say, 2010 or 12 when the property market crashed, and which the debtors were led to believe by these charlatans that there was some legal loophole, some trick of the loop, which would avoid you in one fell swoop, with one mighty leap from your debts, from the clutches of your debts. It doesn't work like that. And I've seen plenty of so-called loopholes, so-called technical defences going down the tubes, quite frankly, in the various courts over the last 10 years or so. But in this case, unfortunately, this couple, badly advised by what the High Court has described as legal charlatans, failed to make any payments since 2017. The judge said that it could take up to 2 years for the possession order to be enforced. He said there was still plenty of time to arrive at a repayment solution which would not involve them losing their family home, because as matters stand, they run the risk of, or will lose their family home. They cannot, according to the judge, pay absolutely nothing to reduce still mounting arrears, avoid any meaningful engagement with START, and expect that the courts will laud their stance or that things will somehow work themselves out. He goes on to say then that a blizzard of documents from the defendants contained oddities, including a document which referred to being a living man and a living woman who are not dead and whose title in their estates had been vested as per Section 4 of your Cestui Qui V Act of 1666. This document, according to the High Court judge, in the best legal language, was wanting in sense. The judge said you cannot escape a debt simply by dying, and he was mystified how an act enacted by the English Parliament in the reign of Charles II had anything to do with enforcing this loan. All borrowers, he urged, should avoid unregulated charlatans who offer false hope that repayment of lawfully incurred debts can be readily evaded through some trick of the legal loop, and to avoid sending correspondence containing fanciful assertions, propositions or text. The defendants never engaged with the substance of what must be engaged with, that is, their continuing default on their loan obligations. He rejected all 27 grounds of challenge, including claims that the Circuit Court had no jurisdiction to make the order, the case could not be brought because one of the debtors had not consented to it, and alleged breaches of human rights law, GDPR and international instruments. There was absolutely no grounds for the debtor's complaints that counsel for Start was quite aggressive and really aggressive towards her during the appeal hearing. Bottom line is, there are very few legal loopholes. They have been tried and tested down through the last 10 years or so. People like this, debtors, unfortunate debtors, are taking advice from what the judge in this case, Judge Max, I can't remember his second name, has described as legal charlatans, people who are giving pseudo-legal advice and referring to natural law and laws going back to 1566 and 1666 and English Parliament and so on and so forth. It's all, as the judge says, a pile of nonsense that simply will not stand up, will not win the day. And in this situation, remember, this default firstly occurred in 2011, and they haven't paid any money since 2017. But when they defaulted in 2011, they owed about 15 grand, 15,000, and they stopped paying in 2017, obviously having taken some bad advice, and having stopped paying from 2017, the debts now, the arrears and so on, have amounted to 60 grand, and the judge has been left with no choice, no legal option from a legal perspective but to grant the order for repossession. But he does make the point that there's still plenty of time to do a deal, but they will have to do a deal. But it's an interesting case insofar as it is more of this technical defence, this legal nonsense, this pseudo-legal gobbledygook, quite frankly, from what he has described as legal charlatans, and the production of documents which are, as he says, wanting in sense. Thanks a lot for listening, and don't forget to subscribe so that you won't miss an episode. And I'd really appreciate it if you'd leave a review on Apple's iTunes. It gives great encouragement and lets me know that I'm on the right track. Thanks a lot.